Good afternoon, everyone. Welcome to another edition of Employment Law Q&A. My name is Alex Lucifero. I am the managing partner of the firm's Ottawa office, and I am an employment lawyer. Employment law is the bread and butter of my work. It's what I do all day, every day, and pretty much my days are filled helping people, answering people's questions, helping them resolve their workplace problems, whatever those problems are, whether it's during an employee's employment and maybe you're having a disagreement with your employer, maybe your employer is trying to force some changes to the terms of your employment on you, or at the end of the employment relationship, if you've been let go from your job, you've been offered a severance package, or maybe you haven't been offered any kind of severance at all. I also assist people in getting the proper entitlements, the proper severance that they are owed when they are let go. That's what I do all day, every day. Guys, this is a live Q&A with an employment lawyer. Now is the time to ask your questions, to get those workplace issues resolved. Please, if you have any concerns with respect to your employment, feel free to ask your questions. Feel free to really address whatever employment issues you want to address here. Obviously, a lot of the past couple of weeks, at least in Canada and in Ontario specifically, have been about mandatory vaccination policies and programs. We've received a ton of questions. We're continuing to receive a ton of questions on mandatory vaccination policies, so we can certainly get into that today. But really, I'm here to talk about anything else that's employment law related. Maybe you've been temporarily laid off from your job. Again, maybe your terms of employment are changing and you don't really agree with those changes, or maybe you've been let go. Now is the time to address those issues. You don't want to wait. You don't want to let these problems lie. You don't want to let these problems sit and fester. They will get worse. If you're dealing with a difficult issue at work, you have to address it right away, and you need an employment lawyer in your corner. Otherwise, you may end up making the wrong decision. You saw our contact information come up on the screen a moment ago. Those are the key pieces of information that you need if you want to contact us, if you are looking to get some advice off air, off our live stream, if you're looking to have a private conversation with either myself or another member of our firm, another employment lawyer. A couple of different places you can reach us. Primary point of contact, employmentlawyer.ca. That is our website. We've got a ton of resources, a ton of information. We have forms that you can fill out so that we can contact you in response. And there's also all of our contact information on the website as well. Another excellent contact point, help@employmentlawyer.ca is our email address, help@employmentlawyer.ca. Again, if you're dealing with an issue at work, if you're struggling with a workplace issue, send us an email at help@employmentlawyer.ca. Someone will respond. I promise you, someone will respond to you, and we'll try and get you on your way to resolving that workplace issue. To get the ball rolling tonight, guys, I wanted to talk about a situation that came across my desk earlier this week. It's actually not to do with mandatory vaccination policies. It's to do with temporary layoffs. Temporary layoffs are an issue that we've been dealing with over the course of the past year and a half. And it's one that really the law has not changed on since the start of COVID. The law with respect to temporary layoffs remains the same, which is the following. An employer is not automatically or inherently allowed to temporarily lay off an employee. That is something that an employee has to agree to. You have to consent to a temporary layoff, and you don't have to consent as an employee to temporary layoffs if you are currently on a temporary layoff, or if you've been temporarily laid off recently and you are in Ontario. You have the right to decide whether you are going to accept that temporary layoff or not. You can decide not to accept it and treat it as a termination. You can actually decide, you know what, I'm not waiting around for my employer to call me back. I want to end my employment and move on. You are certainly able to do that, and that might actually be the better option when it comes to temporary layoffs, receiving your severance package entitlements and moving on to new employment. So we've been dealing with this issue again since the start of COVID, but I'm telling you guys, the law has not changed. These temporary layoffs still require an employee's consent, and you don't have to consent as an employee to being temporarily laid off. You can treat it as a termination. That remains the case in Ontario. So just a word to the wise there for anybody who's still on a temporary layoff. There are lots of individuals, we speak to them every day, that are still on temporary layoff. They've been laid off now for almost 2 years. It's incredible. Those employees should know that they have rights, they have entitlements, and they have the choice. They can make the decision to either continue on the layoff or treat their employment as terminated and get the severance entitlements that they are owed. I see a few questions coming through, guys, which is great. That is what I am here for until 2:30 this afternoon, at least Eastern Standard Time. Just as a reminder, my name is Alex Lucifero. I am an employment lawyer and managing partner of the firm's Ottawa office. Our firm has offices in Ontario, Alberta, and British Columbia. Certainly, if you are dealing with any kind of employment issue, this is the place to be. Go ahead and ask your question. I promise I will get to it, even if it takes us beyond 2:30, but beyond our designated time today. I will get to your question and get you on the path to resolving your workplace dispute. So with that out of the way, guys, let's get cracking on the questions. Tracy, you are first in line. Excellent. If placed on an unpaid leave of absence, Tracy asks, does that person qualify for employment insurance? Good question, Tracy. The answer is probably not, because it's technically not a termination, and so that wouldn't qualify, at least in the eyes of Service Canada, as triggering an entitlement to employment insurance. That said, Tracy, and we're now delving into this topic of mandatory vaccination policies, guys, so bear with me and come along for the ride. Tracy, if you are being placed on an unpaid leave of absence and you are a non-unionized employee, if you are not part of a union, an unpaid leave of absence is basically a termination, in other words. Think of this, your employer is sending you home without work or pay. That is effectively the fundamental right of an employee, which is to work and earn a living and earn pay. And if your employer is not doing that for you, then that is a breach of the employment contract. It's probably the most fundamental breach of an employment contract. So if your employer is sending you home without pay, it's what we call a constructive dismissal, which is basically a termination. And in that case, EI might give you a hard time, Service Canada might give you a hard time, Tracy, with respect to employment insurance, but you would be owed severance in a case like that. So your issue might be more with your employer, who shouldn't be putting you on this unpaid leave of absence, than with Service Canada or employment insurance. And I see your follow-up, Tracy, and yeah, I'm sorry to say, Tracy just mentioned she's a unionized employee, and that is a very, very tough spot, particularly when it comes to this mandatory vaccination issue, Tracy. And as you might already know, whether an employee knows it or not, when you sign up for a unionized job, you are by law agreeing that the union is going to be your legal representative. What that means is that you live and die, your employment does at least, by what your union represents, the issues that it decides to pursue or not. And so if your union, Tracy, has taken the position that these mandatory vaccination policies are legal and legitimate, well, guess what? If you don't agree with that, that's too bad. It's your union that's going to be your legal representative, and that's going to decide whether to champion that issue or not. And lots of unions, of course, are not deciding to champion that issue. And so that leaves unionized employees in a very, very difficult spot where not even someone like myself, who's an employment lawyer, can assist. All right, moving on. Next question. Dave Green asks, can someone be fired for not sharing personal medical information? Further to that, can someone be fired for not getting vaccinated? Dave, you hit the nail on the head in terms of the hot topic of the week and probably of the month and perhaps the rest of the year. I will give you, Dave, the practical answer to your question. Even though legally speaking, I think the answer to your question is probably no. Somebody shouldn't get fired for not disclosing their medical status or for not being vaccinated. That said, practically speaking, Dave, no one, not myself, not you, not any employment lawyer, not any judge or mediator for that matter, or arbitrator for that matter, can stop an employer from letting an employee go. There is nothing that we can do, that anyone can do, to put a pause on that process and to save your job. If your employer is requiring you to be vaccinated or to disclose your vaccination status, otherwise terminate your employment, you are in a very difficult situation where you're going to have to decide. Again, this is practically speaking, guys. I'm not talking about what's legally right or not, but practically speaking, you are going to have to decide between whether you want to get vaccinated and keep your job, or alternatively, double down on your position and lose your job. Now, again, for non-unionized employees, in most industries, almost all industries, if your employment comes to an end, you're going to be owed severance in a situation like that. So even if your employment, even if you're let go, if your employment is terminated, you're still going to be owed a severance package in those circumstances. There are some circumstances where that very well might not be the case, but again, in most, if not all situations, it will be the case. But still, Dave, you're having to decide between getting vaccinated and your job. Not an easy situation. Don't get me wrong. I understand very, very well how difficult that choice is, but that is the practical reality of the situation. Guys, I love the questions coming through. Keep them coming. Like I said, and I promise you this, I will get to every single question that is asked. I don't care how long we have to go for. Again, my name is Alex Lucifero. I'm an employment lawyer in Ottawa, Ontario, with Samfiru Tumarkin. I manage the firm's Ottawa office. I am here to help you resolve your workplace issues and answer any and all questions related to employment law and the workplace. So let's keep it going, guys. Raquel asks, can an employer initiate unpaid leave / termination regarding Directive 6? Raquel, give me some more info on Directive 6 because I don't know what you're talking about. But again, the general point that I just mentioned remains. If you are a non-unionized employee and you're either put on an unpaid leave of absence, or if your employment is terminated because of your vaccination status, you are still owed severance in a case like that. We cannot help you save your job. We cannot keep your job for you. Your employment will come to an end, but you would be owed severance. Esmeralda asks, there is a template circulating called Notice of Liability. Is it necessary? What is the value of it? Can you share a template? Good question, Esmeralda. I have seen these documents, at least from a couple of people that I've spoken to in Ontario, and they're called Notice of Liability documents. I've reviewed them myself. They don't hold any weight in my eyes. I don't think they're enforceable at all. I don't think they serve any practical purpose either. Be careful what you read and what you see on the internet if it's not coming from an expert, if it's not coming from a professional like myself as an employment lawyer. If you are searching chat rooms and random websites, again, be very, very careful what you read and what you see. All right, guys, let's keep it moving. Aglea, forgive me for the pronunciation, asks, can the employer let you go or fire you while you're on short-term leave? Great question. The short answer is, generally speaking, no. An employer cannot fire you while you are on a medical leave of absence, even if it's a short-term leave, with kind of one big exception, I guess, which is if the reason for termination is completely unrelated to your medical leave. If, for example, you work in a particular department or a particular store, and that department is being restructured and all of the employees are being let go in that particular department, or if a store is closing down and you are on medical leave, but your store is no longer going to be operating, well, then the termination may be legitimate because, again, the reason is completely unrelated to your medical leave. Now, in a situation like that, you're owed severance, certainly. You're probably owed much more severance than usual because you're currently medically unable to work, and that means it's going to take you longer to actually go out there and find new employment. Your severance entitlements are enhanced as a result. So to answer your question, the reason for the termination, if you're on a medical leave and you're being let go, the reason for your termination is crucial. If even 1% of the reason why the company is letting you go is related to your disability or your medical leave, that's discrimination. That is a major problem for an employer, because not only will they be owed severance, they're going to be owed significantly more, the employee that is, for other additional damages, human rights damages we call them, because they were let go because of their disability or their medical leave. So if you are being let go, Aglaia, and you're on a medical leave, whether you're on medical leave or not, whatever the case may be, please give us a call, send us an email, fill out a form on employmentlawyer.ca. However you want to get a hold of us, it's important you get employment law advice right away. Do not sign anything given to you by the company. Do not accept any kind of offer. Take the documentation that they've provided you with, go home, gather your thoughts, and give us a call right away. Send us an email right away. help@employmentlawyer.ca is the email address. Send us an email with a brief description of your situation. Attach some documents if you want to attach. It's completely confidential. Someone will get back to you, I promise. All right, let's keep it moving, guys. James asks, can someone collect EI if they are laid off for not getting the vaccine? It's a good question, James. My hunch is no, you probably wouldn't be able to collect EI, or my fear is that some individuals, some representatives at Service Canada will deny a claim in that respect. But again, I think your attention is focused on the wrong entity. If you are being laid off because of your vaccination status, that is a problem you should take up with your employer. Your employer might owe you severance and potentially even other additional damages, depending on your circumstances, if you're being laid off because of your vaccination status, setting aside whatever EI or Service Canada might do. All right, Jesse asks, I work for a telecommunications company in Alberta. My work is said is if I don't get the vax or do rapid testing, they will give me 0 hours until I comply. Is that wrongful dismissal? Could I get EI or severance? Where I hesitate with respect to your question, Jesse, is with respect to the rapid testing. The rapid testing, in my eyes, might be a reasonable alternative to either disclosing your vaccination status or confirming whether you're vaccinated or not. If your employer is offering you the opportunity to, listen, we don't care about your vaccination status. If you're not going to tell us that, you at least have to take a COVID test every so often. Maybe it's once a week. Provided your employer is paying for that test, Jesse, and provided that they are also doing it on a reasonable basis. And otherwise, you're not testing every day or every second day. It's maybe once a week, or maybe even twice a week might be reasonable. But as long as those conditions are being met, that testing is probably going to be deemed reasonable in the workplace. Actually, there's been a couple of decisions, at least in Ontario, that I know of. And these were in unionized environments, guys. So not necessarily in the private sector, in the non-unionized sector, but in the unionized sector. There have been already a couple of cases where COVID testing in the workplace has been deemed a reasonable health and safety protocol and procedure. So my concern, James, is that if you're also refusing that testing, right? I get that you don't want to disclose your vaccination status or that you're not vaccinated. And if that was the only thing that the company was relying on and then sending you home with 0 hours, I would be very clear that that is a termination in my eyes, and you are owed severance in a situation like that. The testing is where you maybe run into problems because testing, again, might be considered reasonable in the workplace. And if you're refusing reasonable instructions on the part of your employer, that might make your severance claim much more difficult. And so my advice, James, before you say anything else to your employer, before you communicate at all with your employer, again, listen, you need advice. We need to know the exact situation you're in. We need to know what kind of conversations you've been having with your employer. Give us a call. We have an office in Alberta. One of our Alberta employment lawyers can definitely help you navigate this situation. Jesse, employmentlawyer.ca is the website. Fill out a form online. Someone will get back to you. Or help@employmentlawyer.ca is the email address. Send us an email with some basic details, and again, somebody will get back to you. You need advice, Jesse, before you do anything else with respect to your employment. Sam asks, I have 4 DUIs. How can I get my truck license and job. Sam, unfortunately, when applying for a job, they might want to do some sort of criminal background check. And if your DUIs come up, that might be an issue if you're looking for a job driving. So you're in a tough spot there, Sam, and you may have to consider other options with respect to your employment. All right, I'm just scrolling through here, guys, just trying to catch up with the questions. Magdalena asks, when new policy in hospital says if I'm not taking the vaccine, I won't be able to work at the hospital. I don't have a union. What should I do? Vaccine is my only chance to keep this job. That is exactly the point, Magdalena. Now, because you are not unionized, if you are let go, if you are terminated by the hospital for not being vaccinated, you would still be owed severance in a situation like this. I'll say this time and time again, guys. Employees who are let go in a situation like this with respect to these mandatory vaccination policies, they would still be owed severance if you're in the non-unionized sector. The difficulty, Magdalena, is, as I mentioned before, a practical one. If you are desperate to keep your job, if you cannot afford to be let go from this job, you are in a tough position, practically speaking. You have to decide, how badly you want to stand on this principle of not being vaccinated and threaten losing your job for it. You're going to be in a situation where you may decide, you know what, I can't risk the job. It's not worth losing the job. I'm going to get vaccinated. Certainly, lots of people have made that decision, and you have to weigh that. It's not a legal issue. It's a practical issue, and you have to decide. And if ultimately you decide, you know what, I'm going to risk being terminated for this issue, that's fine. That's your decision to make. You would be owed severance in a situation like that, but no one can save your job, which means you're going to have to make that decision sooner than later. Erwin asks, I work for Hamilton Health Science from home. I have a medical exemption from my family doctor. However, they want me to send me to an allergist to revoke my exemption. What can I do to protect myself? Interesting, very interesting situation, Erwin. If your doctor has provided a medical exemption from being vaccinated, or has asked for accommodation, for example, allowing you to continue to work from home if you're able to do so, your employer has to respect that accommodation. To send you to one of their doctors or to for an independent medical examination, in my opinion, is probably a step too far, and it's probably unreasonable on the part of an employer. As I mentioned to Jesse beforehand, Erwin, this sounds like a delicate situation. We probably need to know more details specifically about your job and about what's happened here, but you definitely need legal advice. Before you communicate again with your employer at all, really, give us a call, send us an email, help@employmentlawyer.ca. The number to reach us by telephone is on the screen. Please set up a consultation with one of our employment lawyers. We will be able to guide you through a situation like this. If you don't speak with an employment lawyer, if you don't get that legal advice that you need, you may be running into some difficulties moving forward if your employer either tries to play hardball with you, or if you say the wrong thing, make a mistake, which your employer then takes advantage of. Tina asks, how does one make an informed decision to be able to give informed consent when all the data is not available? Tina, less of an employment law issue, more of a kind of general or perhaps even medical issue. Unfortunately, I can't comment on that, but if you have anything employment related, by all means ask away. I will answer. We are starting to get up against the clock, guys, so I'm going to kind of rapid fire these questions. Again, if I don't get to your question today, and I'll try and get to all of them certainly, you know where to find us, employmentlawyer.ca. I've said it, half a dozen times already throughout the course of this stream, but really that should be your starting point. If you're looking for some guidance, if you're looking for some answers, and if you're looking for some contact information in order to reach out to us, employmentlawyer.ca is where to find it all. All right. Natalie asks, if being let go because of all of this COVID vaccine stuff, should I go to work still on the deadline day given by my employer until they give me a termination paper? Natalie, certainly I would write to my employer at the very least. Send them an email, a text message if you communicate with your employer by way of text message, anything, ideally in writing. Reiterating the fact that, you'd like to come to work, you'd like to keep your job. Should I come to work? Should I come to work today? Let the employer say no. Let the employer send you a letter saying your employment is terminated. You don't necessarily want to just disappear into thin air. Your employer might take the position that you've kind of abandoned your employment by not showing up to work. So I would do my due diligence. In other words, I would either send an email or, I guess even show up to work and say, guys, employer, I'd like to make this work. Is there not some way that we can move forward here without me, confirming whether I'm vaccinated or not, and let them send you home. Let them let you go. That is going to be a crystal clear situation. You don't want any degree of uncertainty when it comes to who ended the relationship. Sandy asks, should an employer provide employees with a vaccination policy prior to advising of a due date that employees must be vaccinated by, or can they say you must be vaccinated by X date? However, the policy will be released at a later date. Sandy, certainly, if an employer is doing this properly, they should have a very clear written policy with respect to vaccination and the workplace. Now, it doesn't have to be a beautifully typed up 20-page document that's provided by PDF attachment. It could be in the body of an email. Really, it could be that simple. That might be the extent of the policy, and there's nothing inherently wrong with that. Is it the right way to do it, or is it the perfect way to do it? No, probably not. But you can't pursue an employer. You can't punish an employer just because their policy is very succinct and in the body of an email. What matters, Sandy, of course, is the substance of the policy and what that means for your employment. And I will reiterate again, if you are a non-unionized employee and your employer is requiring you to be vaccinated by a certain date, or otherwise you'll be terminated, you have, practically speaking, to choose between your job and being vaccinated and being terminated, that is. And if you're terminated, listen, you're going to be owed severance. There's no question about that. But you still have to decide whether you want to lose your job over this issue. Kim asks, I am home health aide. I have been union. I was told by October 6th to be vaccinated, or if I do not, will I get severance pay? Kim, you have to ask your union, and you need your union support if you are not vaccinated as to what to do, what's going to happen with respect to your employment. Unfortunately, neither myself or any other employment lawyer, for that matter, can help you if you are a unionized employee. Your union is your legal representative. And they are the ones that are going to have to deal with all of this. Andrea asks, you said in non-unionized employment they would have to pay severance. Are you entitled to severance in a unionized environment? Andrea, if you are let go from your employment in a unionized setting, yes, you are still owed severance. If it's related to these mandatory vaccination policies, and the union is on board with saying, yes, these policies are legitimate, employees should all be vaccinated, then I think you might have a very tough time looking at severance. At the very least, you should be having a conversation with your union about it. Your severance entitlements are probably also quite limited because you are a unionized employee. If you are a non-unionized employee, your severance entitlements are based on your age, your position, and your years of service. They're what we call your full severance entitlements, and they can be as much as 2 years of pay for a lot of employees. That's 24 months of pay. You're not going to get that much severance as a unionized employee. It's the collective agreement that will tell you how much severance you're owed. Muggsy asks, can you get EI if placed on unpaid leave? Muggsy, I've already answered this question, so you can just scroll back through the video and get the answer. I suspect that the answer is no, but I also suspect that, again, your focus is on the wrong entity. If you are being sent home without, it's your employer that you should be taking, not necessarily Service Canada or employment insurance. Particularly if you are a non-unionized employee. Tom asks, are building owners allowed to deny access to unvaccinated people? My work has maintenance contracts with certain buildings that are refusing access to unvaccinated workers. Well, Tom, I don't know necessarily in terms of kind of either construction law or municipal law what the rules, and particularly what the rules in your particular province or area would be with respect to kind of what buildings can and cannot do. But certainly for these workers, the analysis remains the same. If they are non-unionized employees and they are being denied work because of their vaccination status, if they are being told to go home without pay because they're not vaccinated, that is a termination. That employee is going to be owed severance in a situation like that. Those workers have to make the practical decision to decide whether they want to lose their jobs or not. All right, I'm just scrolling through here, guys, and getting to questions that I haven't already answered. Renee asks, if you are fired due to vaccination status, would that constitute a wrongful dismissal case? How is it proven reasonable to require testing for only unvaxxed employees and not vaxxed when it is proven that vax can spread just like the unvaxxed? Very good question, Renee. I think that's a fair point, although the general point remains the same. If you're a non-unionized employee and you are let go because of your vaccination status, it is a wrongful dismissal to the extent that you haven't been offered the proper amount of severance. Remember, that's what a wrongful dismissal is. A wrongful dismissal doesn't mean you were fired necessarily for the wrong reason. It means that you were fired and not paid the proper amount of severance. So Renee, if you are let go because of your vaccination status and you haven't been offered the proper severance package, you're absolutely right. That is a wrongful dismissal. And you should be pursuing that to the extent that you get the proper severance that you're owed. As I mentioned before, severance is based for most employees on their age, their position, and their years of service. The older you are, the longer you've been with the same company, the more senior your position is within that company, the more severance you're going to get, and it could be as much as 2 years or 24 months of pay. Unfortunately, we'll have to end it there, guys. I believe we have another live Q&A coming up tomorrow. That's Friday, September 24th. I believe it's at 1 p.m. if I'm not mistaken. Do tune in then if you're looking. If I haven't been able to answer your questions, feel free to tune in. Again, my name is Alex Lucifero, employment lawyer with Samfiru Tumarkin, LLP. It's been an absolute pleasure speaking with everyone. I hope I've helped you even just a little bit. We will be here next time on a Thursday afternoon next week. We've also got a ton of Q&As throughout the week as well. Do tune in. Have yourselves a good afternoon, everybody. We'll catch you next time.